he has, what's this, $13,000 bond on the 2 counts that are already on his booking screen. So I'm going to add bonds on the other 2, but those 2 amounts remain the same.
All right, so this is Shakira Ingram. She is the new judge assigned to the YSL RICO trial. So we want to get a little bit of information about her background. We want to try to get a sense for what her style of judging is, so on and so forth. So right at the outset, I'm going to go ahead and say it. She is a former prosecutor, y'all. So I don't know if that's good or bad, but we're going to give it a quick womp womp and we're going to keep going. So we took a look. As you can see from the beginning of this video, a little bit later, we have a couple of court cases that she ruled on. So definitely hang out until the end so you can see, kind of get a feel for her style and how she goes about everything. So Miss Ingram, she's a graduate of Clark Atlanta University and Georgia State, and she's handled several high-profile cases. Just in June, she was involved in the Raisa Kigney case. Raisa is accused of a 2022 Midtown shooting spree, and Judge Ingram determined that Raisa is not competent to stand trial. So it looks like at this point that'll probably be assigned to another judge whenever Raisa is going to be ready to stand trial, because I think Judge Ingram is going to be busy with YSL. In 2022, she also sentenced Sheldon Dooley for the 2016 fatal shooting of aspiring rapper Jerome Blizzy Blake. So she gave Sheldon 2 life sentences plus 45 years after his conviction on 14 counts, including murder and felony murder. So Keith Adams, as you all may know, one of the YSL defense attorneys, expressed confidence in Judge Ingram's fairness and impartiality. He noted that she's conscientious, has a deep legal knowledge, and from his long-term acquaintance with her, he feels confident that she will do a good job as the judge in the YSL RICO trial. So in order to help you all get better acquainted, we took a look and found some cases that she ruled on back in 2022. The first of which was a bond hearing. And as you see, she lets this guy get his bond, so that might be good news for YSL. It's just one case. I know you can't extrapolate out from one case, but it's good that the example that we have of her is of her helping somebody get free. The second case looks like a sentencing hearing. She also seems pretty fair in that respect as well. So take a look at these videos and try to get a feel for the judge who's coming up, who's going to be presiding over the YSL RICO trial. And let me know, what do y'all think? Drop some comments. Don't forget to like. Don't forget to subscribe.
Right.
And let me know what you think. What do you think is going to happen?
For discovery, and we'll get Mr. Wiggins on a case management calendar. Asked to bond. Ms. Bryant, you may proceed.
Your Honor, my client is 51 years old. He is a native of Oakland, California. However, he's been in the Atlanta area since 2015. Your Honor, he has a GED and is a certified carpenter. He worked as a mobile mechanic for the last few years. He has 16 children, and 7 of them live with him. The victim in this case is one of his sons. He also has 3 grandchildren that live with him. Before he got arrested, Your Honor, he applied for SSI and is waiting on confirmation from that. And he has some behavioral health diagnosis. Judge, in this particular case, we believe that it should be resolved. We have a couple of eyewitnesses that can attest to a different set of facts that have been presented to the state. So we would ask the court to consider a reasonable bond. I don't have his GCIC in front of me, but I do believe, based on my conversation with Mr. Wiggins, that his last felony conviction may have been 30 years ago. So we would ask the court to consider a UJR or either a substantial reduction in his bond amount. I believe he's been in custody for 282 or a little bit more than that, 282 days. And like I said, there's some dispute as to what actually happened that night. It does appear also, Your Honor, that he has been indicted on a total of 4 charges, but he's only has a bond for 2 of those charges. So he would need a bond set for the terroristic threats and the possession of firearm during the commission of a felony.
Okay. May I hear his history, please? Ms. Harvey from pretrial, may I start with you?
This is the first arrest out of Georgia, 23 cycles out of the state of California. It appears that the last felony conviction was in 1990 for transporting and selling narcotics. Nothing further, Your Honor.
All right. And Ms. Counsel, do you have anything to add?
No, Your Honor.
Okay. Mr. Lewis, I'll hear from you.
Thank you, Your Honor. Give me 1 second. Let's see what the. Right, Your Honor, I'm just kind of looking at the alleged facts of the case. It seems to be on video that a handgun was pointed at the defendant's son. With that in mind, we believe the current bond is appropriate. We've asked that it be maintained in its current state. If Your Honor is inclined to grant a bond, then we ask for no contact with the victim.
Is the alleged victim an adult or a juvenile?
Pull that right back up. It's going to be an adult, Your Honor.
Okay. Ms. Bryant, does your client live at the same location as Keyshawn Wiggins?
They do not, Your Honor.
Okay. So your client's address at Bookend is the same address as listed for the victim?
That's what's in the police report, Your Honor, but I'm not sure if they.
I've spoken to my client as well as his wife, and they both contend that the victim does not live there.
Okay. Okay, bond will be set as, the bond he has, what's this? $13,000 bond on the 2 counts that are already on his booking screen. So I'm going to add bonds on the other 2, but those 2 amounts remain the same. So the ag assault will remain at $8,000. The terroristic threats will be an unsecured judicial hold through pretrial services under level 1 supervision. Possession of firearm by convicted felon will be $2,000, and the possession of firearm during the commission of a felony will be $5,000. So the total bond is a good bond of $20,000. The conditions are no further contact with Keyshawn Wiggins. He cannot possess any weapons or firearms.
Thank you, Your Honor.
I will allow the 3 good bonds to be postable through the sheriff's 10% program. Okay. All right. We are finished with Mr. Wiggins. Thank you.
He was located in Zone 6, Fulton County. That address was 241 Forsyth Street. Your Honor, just as a few extra things, the state has attempted to make contact with victims in both indictments cases. No victim has returned a call. We do believe that if there is restitution, we would ask for 15 days for any victim to provide that. Once those 15 days have passed, restitution will be foregone, and the state has informed each victim in the case via message of that possibility. I believe that's all from the state, Your Honor.
All right. May I hear his history, please, starting with Ms. Harvey?
That reminds me, Your Honor, we are also withdrawing the recidivist notice on this one as well.
Okay.
43 cycles out of the state of Georgia. Also arrests out of Connecticut, Maryland, and North Carolina, and 4 arrests out of South Carolina. Felony convictions include a 2011 possession of cocaine, a 2012 possession of cocaine, 2014 possession of cocaine, 2014 theft by conversion, 2017 aggravated assault, and a 2020 criminal attempt to commit a felony. That's out of DeKalb County. He was sentenced March 9th, 2020 to 4 years probation, Your Honor. In addition, we are showing a probation violation hold out of Gwinnett County. Nothing
right.
further, Your Honor.
Thank you. Ms. Counsel, you have anything to add?
Yes, Your Honor. Only that he was charged as a first offender in July 2004 out of DeKalb County for forgery. And he has an active warrant out of DeKalb County for the probation violation, Your Honor.
All right. So Ms. Counsel, since he has active probation, should I give him reporting instructions just to report within 48 hours of release, because he's going to go from here to the holds?
Yes, Your Honor.
Okay. All right. Mr. Edwards, you understand the nature of the charges against you?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or any other substance at this time?
No, ma'am.
Has anyone threatened you in any way or promised you anything to influence you to plead guilty?
No, ma'am.
Do you understand that by pleading guilty, you give up all of the rights that the assistant district attorney just outlined for you?
Yes, ma'am.
And are you willing to give up those rights today in order to enter into this plea?
Yes, ma'am.
Do you understand that if you are not a United States citizen, this plea could have an impact on your immigration status?
Yes, ma'am.
Do you understand that I am not bound by any promises, recommendations, or reductions, but that I can sentence you as I deem appropriate?
Yes, Your Honor.
How do you plead to the charges on these two indictments?
Guilty, Your Honor.
And are you in fact guilty?
Yes, ma'am.
And are you entering these pleas freely and voluntarily?
Yes, Your Honor.
Ms. Bryant, are you satisfied that your client is competent? He understands what is going on, that the plea is voluntary, and that there's a sufficient factual basis for the plea?
Yes, Your Honor.
Okay, I will hear from you.
Your Honor, we'd ask the court to accept the negotiated plea that we had worked out with the state. My client is the father of 3 sons, ages 10, 9, and 6, and they are currently in the care of his elderly mother. So he was anxious to resolve this matter, and we're glad that we're able to resolve it to a point where he can accept the terms. My client takes full responsibility for his actions in this case, and both of these cases are based on Mr. Edwards having permission from the owners of the cars, but him not returning the cars in a timely fashion. So he understands where he went wrong in this case and is taking full responsibility for that. So we would ask the court to accept the negotiated plea. Thank you, Your Honor. And we have no objection if the court rules that we hold the restitution open for 15 days. We do not have any objection to that.
Hold it over for 15 days. You mean like to have a hearing?
No.
No, Your Honor, just for the victims to return back with the restitution amount, if there is one.
Okay.
Yeah, so if they provide anything, I'll provide the court and then request a hearing, but if not, then we can just forego everything.
Okay. All right. I find that there's a sufficient factual basis for the charges, and I further find that Mr. Edwards' plea of guilty has been entered knowingly, voluntarily, and intelligently. I will accept the pleas and sentence as negotiated on 22 SC 180666. Counts 1 and 2 are 3 years to serve 5 months balance probated. Count 3, 12 months to serve 5 months balance probated. All counts to run concurrent with credit from December 7th, 2021 to present. And then on 22 SC 181855, on counts 1 and 2, 3 years to serve 5 months balance probated with credit from April 25th, 2020 to September 10th, 2020, as well as December 7th, 2021 through present. The state will have until June 8th to advise the court if a restitution hearing is necessary. If not, the sentence will proceed as announced. If a restitution hearing is needed, I will schedule one and amend the sentence appropriately at that time. Mr. Edwards, once you are released, you have a couple of holds to take care of, but once you are released, you'll need to report to probation within 48 hours.
Yes, ma'am.
Okay?
Yes, Your Honor.
All right, thank you. You're free to
Thank you
leave the
very
booth, sir. Mhm.
Thank you very much, Your Honor.
Thank you.
Thank you, Ms. Bryant. All right, thank you, sir. Am I free to go?
Yes, you are. Thank you.
All right, thank you.